Hello, my name is Dr. Ngozi Okoye. I'm a senior lecturer in law at the Lincoln Law School. This is the Lincoln Bitesize on the topic of law contract terms. So, how do we identify contract terms? Well, the approach of the courts is to think about the intentions of the parties. So the question is, did the parties actually intend the term to be contractually binding on them? Now, this is a matter of objectivity. So there is a clear question as to what a reasonable third party would have understood the parties to have intended. And in determining this, the courts of law consider a number of factors. One factor is the knowledge of the parties. In other words, the relative knowledge of either party in regard to the term in question. Another factor is reliance on the other party and the importance of that statement or term at the time of contracting. A third factor is the issue of writing, or you could say the parole evidence rule, which basically connotes that when parties have recorded the whole of their contract in writing, there is a presumption that the written document contains the whole of the contract. In other words, whatever is in that written document is considered a term that the parties intended as part of their contract. We have different types of terms. We have express terms, and then we have implied terms. Now, express terms refer to the terms that the parties have clearly expressed in the contract. One important issue as regards express terms is that it must be incorporated into the contract for it to be binding. And in contract law, we have tests of incorporation. In other words, the factors or the issues that will determine whether a term is properly incorporated into the contract. Now, these tests include the issue of signature, the issue of reasonable notice of the term being given. The third issue is that the more onerous the term, then the more notice of it should have been given. And then the issue of timing, which is that a party is not expected to be bound by terms that they had no notice of at the time that they went into the contract. And then there's also the issue of course of dealing. There is a presumption that if a party has been dealing with the other party on certain terms over a consistent period, then for the reason of course of dealing, they're expected to have notice of the terms in question. Terms could also be implied. In other words, they are not expressed in the contract, but the courts will imply them into the contract. And this can happen in a number of ways. So terms can be implied in fact, terms can be implied by custom, they can be implied in law, and they can also be implied by statute. Terms are implied in fact through the application of two tests, the officious bystander test and the business necessity, or you could also say business efficacy test, as was seen in the case of the Moorcock. In Attorney General for Belize v. Belize Telecom Limited, Lord Hoffman had indicated that in implying terms, the question for the courts of law was whether such a provision would spell out in express words what the contract would reasonably be understood to mean. Now, this argument made by Lord Hoffman has been clarified by the Supreme Court in 2015 in the case of Max & Spencer plc v. BNP Paribas Securities. And in that case, the point was clearly made that actually the business efficacy test or the officious bystander test is essential for a term to be implied in fact. Terms could also be implied by custom. as can be seen in the case of Houghton v. Warren and British Crane and Hire v. Ipswich Plant Hire. Terms could also be implied in law. Lord Denning and Baroness Hill make the point clearly in these cases on the slide. And essentially, terms are implied in law when the contract is of a sufficiently common type and there is a gap to be filled. Basically, when it comes to implying terms in law, the courts consider wider policy implications and the issue of fairness. Terms can also be implied by statute. For example, the Sale of Goods Act 1979 contains sections that imply certain terms into a contract of sale. Similarly, the Supply of Goods and Services Act 1982 does have some provisions as well. And more recently, the Consumer Rights Act 2015 contains certain provisions that are implied into a contract. Now to the issue of exclusion of terms usually implied. The position of the law here is that any term which would otherwise be implied will be excluded if it is inconsistent with an expressed term. And this was said to be a cardinal rule by Lord Neuberger. And in the case of lesser fruitary units, an express term in the contract excluded the application of a customary term. Now on to categorization of terms. This is important because of the consequences of breach. We have major terms and we have minor terms. Now, a major term is such that any breach of it will give the right to repudiate, in other words, terminate the contract, plus the right to claim damages. However, the breach of a minor term will give rise to claim damages, but there will be no right to repudiate, whatever the actual consequences of the breach. Now, in relation to major terms and minor terms, a condition is a major term and a warranty is a minor term. Now, the status of a contract term as either a condition or a warranty is determined in a number of ways. One, it could be determined by statute. For example, those sections of the Sale of Goods Act 1979 in relation to implied terms. It could also be determined by the importance of that term to the contract. This came true in Poussard v. Spires and Bettini v. Guy. It could also be that parties label their terms as either conditions or warranties, but that is not conclusive, and the courts of law could also step in to actually determine whether a term should be a condition or warranty. And we also have another category, innominate terms. This came through in the case of Hong Kong Fair Shipping and Kawasaki. And the issue here is that when it comes to innominate terms, the right to repudiate depends on the seriousness of the consequences of the breach and not on the breach itself. One advantage of this is flexibility for the courts, but a clear disadvantage is that it will create uncertainty. Now let's summarize. Contract terms are very important, particularly as regards determining the parties' obligations and issues of breach of contract terms. The courts consider a number of factors in order to determine the terms of a contract. As regards express terms, key issues to think about are incorporation, interpretation, and the consequences of breach. Terms may also be implied in a number of ways, in fact, by custom, in law, or by statute. Terms may be categorized as major terms, in other words, conditions, or minor terms, in other words, warranty, or they could indeed be considered as innominate terms. Thank you.